Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we continue to look at the Delphi case. If you've never heard of this case before, I would highly recommend checking out my playlist, which I put in the description box for you, and maybe even yesterday's live stream, which is from January 29th of 2024, because we went over all the latest documents in this case. Today, we have an updated document, which is now a filing from the state prosecutor. For about a year now, this case has been all about the back and forth battles, between the judge, the defense attorneys, and the state prosecutor. And it's just at this point, it's really disappointing because it seems like the judge is just incapable of being professional, neutral, impartial. I mean, what we read yesterday in some of those documents, hearing that she didn't even sign off on the invoices, the forms, just to let these court-appointed attorneys be paid. Ooh, that just stacked on top of everything. The comments that she's made on social media, the way that she dismissed those attorneys. This is just really not going well. I would really hope that she will recuse herself. I think it's time for that, but, from everything we've seen from this judge, I don't think that's going to happen. But let me know what you think in the comments below. I always love reading your comments. No matter where you fall in this argument, just remember that if you disagree with my opinion or everyone else's opinions here, there's, majority of us are like red flags. Something's going on, something isn't right, and we're not alone in this either. There's many American attorneys saying the exact same things as me, which I'm not an attorney and I'm not American. So it's just the whole world is watching. And what's happening here in this case isn't right. It's just not the way things should be done. This is not the road to a fair trial for the suspect. It's not how the suspect should be treated, by throwing him basically in a prison, in a cage, and being like, oh, well, who cares what happens to him? Why, for example, why isn't the judge more concerned about that? Why is the prosecutor not more concerned? Why do they want that problem to go away? Why does the state prosecutor say he doesn't really care where the suspect is, as long as he's safe? Okay, well, if you don't care, why fight so hard to have him in a prison 233 miles away, rather than what his defense attorneys are suggesting, which is a jail within 20 minutes from them? Why make it so difficult? It's a little bit strange, right? So, my goodness, it's been a lot. And I think it's been really interesting and an example of really what not to do, especially as a judge. Oh dear. But nevertheless, if you want to catch up on all of that backstory, we've done so many episodes, so I hope you'll check that out. Today, what I really want to bring you is a follow-up, as I say, from yesterday's live stream, where now the state prosecutor Nicholas McCleland has sort of clapped back. He's it seems like, coming to Judge Gull's rescue, and it's a bit of a desperate attempt to, in my opinion, regain control of the case in some way, but it's just not helping the situation. Really, one would think, now that they've been to the Supreme Court of Indiana, issues have been raised there. It was so intense, that hearing. If you didn't check it out, it's also on the playlist. Oh man, for the Supreme Court of Indiana to decide to reinstate Richard Allen's former defense attorneys. That says a lot. And now, one would think, just play nice. They said the most important thing now is to get this case back on track. And it doesn't seem like that's happening right now, because the judge just immediately denied all these defense attorneys' motions, even though when she appointed 2 defense attorneys to replace them, she said that she'll hear all of the pending motions from them. As soon as the former attorneys were reinstated, she said, nope, denied. She denied all of their pending motions, which is also not fair. It's not right. She should have those hearings. Like, really, what is her problem? And if she has a personal problem with these defense attorneys, get off the case. Because clearly, you cannot be impartial. Whew, it's so frustrating. Okay, so I'm quickly going to show you a Hoosier public defender's post from X. His name is Shay Hughes. And I find all his posts very informative as well, because it's obviously from a legal perspective. So let's have a look at what he says.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
Okay, so Shay Hughes says, earlier this week, Judge Gull denied Allen's suppression and motion in limine without a hearing. This order is problematic. When contesting a search warrant, an evidentiary hearing is mandated if 1. There are allegations of deliberate falsehood or of reckless disregard for the truth, and 2. These allegations are accompanied by an offer of proof, affidavits, sworn statements, etc. Nevertheless, a hearing is not required if there remains sufficient content in the affidavit after the contested content is removed. In this instance, Allen contends the state recklessly disregarded the truth in part by omitting several statements. Betsy Blair's description of the vehicle and the suspect appearing younger, Sarah Carbar's statement of no blood and observing a different colored jacket, and Allen's statement that he was not on the trail after 1:30 p.m. Accompanying the motion and memorandum was a number of exhibits. The state filed a response stating information was not omitted, but didn't provide any further argument in support. Good luck finding probable cause after removing these statements from the affidavit. Thus, in my opinion, a hearing is required. Also note, if granted, the suppression would be dispositive of this case. In other words, Allen's liberty is dependent on this motion. Further, it involves the search of one's home. Indiana has consistently held that when protected property interests are implicated, the right to see some kind of hearing is paramount, and then they cite a case there as well. All the more reason a hearing should have been conducted. Further, the court is not using the correct standard of review. Gull found there was a reasonable belief evidence of a crime would be found in Allen's home, but the standard of review for a challenge search warrant isn't a reasonable belief. Instead, a reviewing court is tasked with determining whether the judge has a substantial basis for concluding probable cause existed. So I want to show you one more. In fact, I want to show you two more. This one says, if I was McCleland's chief deputy, I would advise him to back off on the safekeeping issue. Motion originated with the sheriff, granted without counsel and hearing. If you push back on this issue, the public will think that you're more interested in breaking the defendant than you are justice. And that is what it seems like, right? Setting aside any claims from defense, Allen doesn't pose a threat to others. Likewise, greater danger to himself at a county jail is completely speculative. All told, if convicted, people will question the veracity if he remains in the DOC. And then this one. Today, the state filed information for indirect contempt. That's the document we're going to go over. But I thought I'd first read this and then we'll read the document, right? The state contends the court's gag order was violated in December 2022 when Baldwin sent an email to Brandon Woodhouse. Thereafter, in October 2023, there was the leak involving Westerman. Further, the state contends screenshots show Westerman and Baldwin discuss the case and candidly talk about the court and state, displaying a free flow of information protected by the court's gag order and protective order. Notably, the only exhibit provided with the information is the press release. For indirect contempt, it must be shown a person willfully disobeyed a court's order. In other words, there must be a deliberate intent. Keep in mind the gag order prohibits extrajudicial statements out of court by means of public communication, while the protective order governs discovery. In this instance, it is difficult to come to the conclusion Baldwin willfully disobeyed the gag and protective orders. First, the December 2022 email was mistakenly sent to the wrong person. So again, if you don't know about any of this, just check out what we've covered so far on the playlist, because we went over all of this before, right? Second, the state in a separate cause contends Baldwin is a victim of conversion. The state is the state, even if it acts through a different prosecutor, as both are privy in the investigation of the October 2023 leak. See Becker, and that's of course a case reference. Moreover, the state even references Westerman's affidavit testifying that he took photos of discovery without permission. Third, the conversation between Baldwin and Westerman was a private communication, not a means of public communication. Further, the information does not allege any discovery materials were provided to Westerman. Simply put, we are crossing into dangerous territory if the state contends an attorney is not allowed to privately communicate his feelings about a court or prosecutor. Finally, the state has been provided over a year to address the email and several months to address the leak. At some point, the state must expeditiously address such matters if it contends they are contemptible. Summarily, I am having trouble coming to the conclusion either order was willfully violated. In fact, you won't find willful in any form within the state's information. Okay, so let's look at this latest filing from Nicholas McCleland, the state prosecutor. It was filed on the 29th of January 2024 at 4:34 p.m. State of Indiana versus Richard M. Allen. Verified information of contemptuous conduct. Comes now the state of Indiana by prosecuting attorney Nicholas C. McCleland and brings to the court's attention, which isn't that Judge Gull's attention, but okay, as an officer of the court, verified information of contemptuous conduct by defense counsels Brad Rosie and Andrew Baldwin. I mean, does he want them to get dismissed again? Pursuant to IC 344735D, the state would ask the court to order Brad Rosie and Andrew Baldwin to appear before this court and show cause if there be any reason why they should not be held in indirect contempt for violation of this court's orders. The state would ask the court to consider the following information. This is an interesting clapback from the state prosecutor, Nicholas McCleland. And I say clapback because it's directly following the defense's motions asking for the judge to be disqualified or for her to recuse herself. So this is kind of like the state prosecutor being like, oh, okay, you want to fight. You want to play. Well, let me list all the things that you've done wrong. I think it's a much bigger issue than that, because of all people, the judge needs to remain professional and impartial. No bias allowed, okay? Just be a judge. So let's see what McCleland has to say here on his list. Okay, number 1, that both Brad Rosie and Andrew Baldwin were appointed by this court to represent the defendant herein as public defenders on November 14th of 2022. Which means, yes, Judge Gull, please sign the invoices so these public defenders can get paid. Word. Number 2, that a hearing was held on November 22nd of 2022 to resolve preliminary matters. The same day, the state of Indiana filed a motion for an order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication, commonly referred to as a gag order. So the state filed that motion, but I don't think the judge had responded yet. So there's this little gap where the defense attorneys released like a press release, and they also spoke a little bit to the media. But as I say, I don't think the gag order was officially in place yet. But let's continue. Number 3, that the court took the state's motion under advisement, but an in-chambers conference, defense counsels Brad Rosie and Andrew Baldwin refused to agree to the state's motion, stating that such an order, i.e. gag order, was unnecessary because they had no intentions of discussing this case in the public. I would love to see transcripts for that in-chambers conference, and I would love to see the wording of how supposedly these defense attorneys refused to agree to this. It would be interesting. But as we know from this case, the Supreme Court of Indiana kind of has to get involved for Judge Gull to release any transcripts. So not hopeful for us seeing that. Number 4, that on December 1st of 2022, the defense put out a press release that included extrajudicial statements by means of public communication that commented on the case to the public and to the media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence that they believe proves the defendant's innocence. The information released would have been in direct violation of the gag order that the defense would not agree to, and which the defense stated was unnecessary because they were not going to discuss the case in the public or the media. The press release is herein attached as State's Exhibit 1. 5. That the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing an adjudicated proceeding in this matter. 6. That the court entered an order on December 2nd, 2022 granting the state's motion for order prohibiting the parties. So they released that little press release, spoke to the media before this was even in place. Oh my word. Okay, so anyway, granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication in the whole without a hearing. So in case you're wondering why aren't we hearing from Superintendent Dakota or family members or anything anymore, there's a gag order in this case, all right? They said the order directed the attorneys not to comment on this case to the public or to the media directly or indirectly by themselves or through any intermediary or in any form. The court reminded counsel at that time that they were bound by the rules of professional conduct, Rule 3.6 about trial publicity. This order is commonly referred to as the gag order. The court commented that this order was put out in response to the press release So they put the order out in response to the press release, but now they're saying the press release was not right because they want a gag order. Well, you can't complain about something that they violated, which wasn't even in place yet. It's so frustrating. Okay, so moving on. Okay, so that sometime, the press release was released by defense counsels Brad Rosie and Andrew Baldwin. 7, that sometime in December of 2022, defense counsel Andrew Baldwin violated the court's gag order by sending an email. He didn't violate it on purpose. He literally made a typo. You know when you fill out someone's name when you're going to email someone? Unfortunately, he was typing Bradley for Rosie, and it went to Brandon Woodhouse. It autofilled. He typed something up and sent it. So he was a little too quick on that email, right? But he didn't on purpose be like, I'm going to now email Brandon Woodhouse, which was also one of his clients, by the way, who has a YouTube channel, and we've looked at little clips from that before as well. So they say defense counsel Andrew Baldwin violated the court's gag order by sending an email to Brandon Woodhouse containing an outline of the discovery, including the names of juvenile witnesses. Brandon Woodhouse is not an attorney on this case and is not involved in this case in any capacity. 8, that further, defense counsels Brad Rosie and Andrew Baldwin failed to notify the court or the state of the dissemination of information in this case to an unauthorized recipient and intentionally withheld that information from the court and the state by asking Brandon Woodhouse to delete the email. Interesting that this leak of information was not discovered until the state uncovered it on Brandon Woodhouse's YouTube channel in March of 2023. So McCleland's watching YouTube videos. Okay, interesting there. Also interesting because he's so afraid of 30-second deep fake clips that these YouTubers might make if they have cameras in the courtroom. And remember that he was also the one who didn't want the probable cause affidavit released to the public because he said that they anticipate more arrests. So are there going to be more arrests, or is that just something he made up so that they don't release that to the public? That PCA, it's not the most riveting PCA of all time. Anyway, so further it was discovered that Brandon Woodhouse has disseminated the information to several other people, and his YouTube channel was viewed by multiple viewers. This dissemination of material from the case is a violation of the gag order that directly relates back to the defense counsel. 10, that on February 13th of 2023, the state filed a motion requesting a protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case and or to the public. Interesting date there, because it was in February or March, was it not, that the Murder Sheet podcast interviewed Mitch Westerman. So, hey, if one wanted to have a theory about that, the timeline, one could, okay? If you know what I'm saying, then you know. So then, that on February 17th of 2023, the court granted the state's motion to put in place a protective order setting forth very restrictive rules to prevent dissemination of the discovery in this case to the public or to anyone not involved in the case. 12, that in October of 2023, the state was made aware by the families of the victims that crime scene photos were leaked to the public. That's very sad if the families made the state aware, that the families saw this first. That is horrifying. I can't imagine what they've been going through with all this going on. Indiana State Police began an investigation into how the photos were leaked. It became immediately obvious that the leaked photos came from the defense. On September 18th of 2023, the defense filed a Franks motion with a memorandum in support. The memorandum described the crime scene in gory, graphic detail. As part of the memorandum, the defense attached exhibits that were provided in hard copies to the state and the court. Some of the exhibits were side-by-side photos that the defense created and photos of the crime scene that the defense had altered. These photos were the photos that were leaked to the public. 13. That investigated... Wait. Just back it up. So as part of this Franks motion with a memorandum in support, the memorandum described the crime scene in gory graphic detail. Okay. As part of that memorandum, the defense attached exhibits that were provided in hard copies. Is that like the odorous patches and badges? Or which photos are they talking about there? They say some of the exhibits were side-by-side photos that the defense created and photos of the crime scene that the defense had altered. Okay, these photos were the photos that were leaked to the public. Were they though? Okay, moving on. 13, that investigators were led to a podcaster who said that he got the pictures from an individual that he knew. The investigation led officers to determine the podcaster got the photos from a man that he knew who got them from Robert Fortson. Robert Fortson received the photos from Mitch Westerman, who is tied to the defense. Robert Fortson is the man who took his own life after the police had gone to speak with him, and in previous filings, Nicholas McCleland said that he wouldn't talk to them and asked for an attorney. So to now say that Robert Fortson was saying where he got it from and all of that, it's interesting. There's a lot of inconsistencies in what Nicholas McCleland says as well, Okay, so now 14, which doesn't make it better. 2 wrongs do not make a right. It's not even about that. It's just like, this guy, if Judge Gull was as hard on the state prosecutor as she is on the defense team, there'd be a lot to, think about. There would probably be a whole new team required. Anyway, so off we go. They said that on October 10th of 2023, defense counsel Andrew Baldwin stated on a conference call with all parties, which was off the record, that a trusted confidant by the name of Mitch Westerman stopped by his office to visit, snuck into his conference room, where all the discovery in this case was being held, unsecured, and took photos of crime scene pictures. Defense counsel Baldwin stated that this occurred without his permission and that the pictures were stolen. Ironically, this was hours after investigators spoke to Fortson, which, if I remember correctly, because I'm a pretty visual person, I don't know if this timeline that McCleland is now presenting is correct. But they said, ironically, this was hours after investigators spoke to Fortson, who didn't want to talk to them, and determined that Mitch Westerman leaked the photos, and he was the connection to the defense. Okay. And 15, that the investigation by the Indiana State Police revealed that Mitch Westerman previously worked for Baldwin and was a person Baldwin trusted. In an interview with Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memorandum to review. Defense counsel Baldwin also stated that he gave the Franks memorandum to another civilian to review. The Franks memorandum and exhibits contained protected discovery information that included very sensitive crime scene photos that were leaked by Mitch Westerman. Well, if he gave him a copy of this Franks memorandum, why would he need to sneak into the conference room to take pictures of those crime scene photos? Which is why I question, are the exhibits that were attached to this Franks memorandum the same photos that he allegedly disseminated or not? That would be interesting to find out. Specifically, the investigation revealed that Mitch Westerman gave the photos to an individual named Robert Fortson, who then passed them on to individuals who distributed them throughout the internet. I still wonder what Mitch Westerman's motive was, especially thinking about the timing of his interview with a podcast, the timing of this non-dissemination order, all of that. Okay, so 16, that on October 12th of 2023, defense counsel Brad Rosie submitted a letter to this court admitting that both he and the defense counsel, Andrew Baldwin, had agreed to store the discovery in the conference room in the defense counsel Baldwin's office. Further, defense counsel Rosie admits that Mitch Westerman had access to the conference room and took the photos. Finally, defense counsel Rosie admits that it was negligent on the part of the defense counsel to allow Mitch Westerman alone in the office where sensitive discovery material was stored. See Section 4 of the letter filed with the court. Then, in Section 10 of the same letter, defense counsel Rosie accepts responsibility for a lapse in security that caused the photos to be leaked. According to this court, that they are in indirect contempt of the court's orders. Again, they didn't do it on purpose. Yes, it was out on that table, but it's not like they on purpose violated this court's orders. 17, that on October 18th of 2023, Mitch Westerman submitted an affidavit to this court stating that he in fact went into the conference room of defense counsel Andrew Baldwin and took pictures of discovery evidence without the permission of defense counsel Baldwin, which is why he's now in jail, and he, ironically, had a hearing on the very same day that the Supreme Court of Indiana hearing happened for Richard Allen and his defense team, which was reinstated. I haven't seen any updates from that. No documents, no updates or anything, so I'm not sure how that's going. 18, that investigators were able to retrieve messages between Robert Fortson and another individual that showed that Robert Fortson had detailed real-time knowledge about when evidence was submitted to the defense and the contents of that evidence for weeks before the photos were leaked. Fortson also knew the actions the defense took in trial preparation, leading law enforcement to believe that this was not a one-time act of one person, but a consistent leak of information and discovery in the case. The investigation showed that Westerman would get information about the case and then give it to Fortson, who would distribute it to other individuals. It's kind of weird to bring up, Robert Fortson the whole time in this document, because you could see it's going to be brought up more, because he is not here to speak for himself or defend himself in any way. He took his own life. 19, that investigators attempted to interview both Mitch Westerman and Robert Fortson, each of which declined. So there you go. 20, that shortly after investigators attempted to interview Robert Fortson, he took his own life. An investigation into that death led law enforcement to find out that shortly before his death, he had expressed concerns about the open investigation concerning the discovery leak in this case and stated to someone that if he just came clean, all this would go away. 21, that a search warrant on the iCloud account of Mitch Westerman revealed screenshot photographs of conversations between Mitch Westerman and defense counsel Andrew Baldwin, wherein they candidly discussed the Richard Allen case, and candidly talk about the court and the state displaying a free flow of information that is protected by the court's gag order and the order protecting discovery. When I paused there and I said, well, it's the Delphi case. It's the case for Abby and Libby. But yes, Richard Allen is the one going to be on trial. One just wouldn't think the state would be like Richard Allen's case at this point. Anyway, 22, that the investigation shows that defense counsel failed to secure evidence and discovery materials in this case, specifically graphic crime scene photos, which were then distributed to the public and put on the internet in violation of the court order dated February 17th of 2023, and evidence supports a conclusion that the disclosure was ongoing. If anyone wonders if I've seen those photos, I really haven't, and I really don't want to. 23, that on October 19th of 2023, and again at the hearing held on October 31st of 2023, David Hennessy, attorney for Andrew Baldwin, suggested to the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. That's really taking one angle of it. I mean, he was there to defend and represent Andrew Baldwin. 24, that the state was notified in the beginning of the leak by the defense by the families of the victims. Since that time, the state has had an opportunity to talk to the families of the victims about the photos and information that was leaked. The amount of harm and re-victimization that this has caused the families of the victims is, he said, unmeasurable, immeasurable, and incurable, which I can only imagine. It's terrible for the families. 25, that the press release and the 2 occasions of leaked information show a trend by defense counsels Brad Rosie and Andrew Baldwin of not being completely honest with the court, violating the court's gag order set in place to protect the integrity of the case, and failing to comply with the protective order put in place to protect the discovery in this case. Wherefore now comes the state of Indiana, by prosecuting attorney Nicholas C. McCleland, and swears under the penalties of perjury that the information above is true and accurate to the best of the state's knowledge based on the filings, personal knowledge, and police investigations. The state asked the court to issue a rule to show cause order based on this information and set this matter for a hearing and order attorneys Brad Rosie and Andrew Baldwin to appear and show cause, if there be any, why they should not be held in contempt by this court. Okay, will there also be a hearing for why Judge Gull should recuse herself? Because that needs to happen too. You know what I mean? So here as well saying that there is a pattern, they said a trend of them not being completely honest. Yeah, right back at you. Trend as well with Judge Gull doing the same. Anyway, so here they've got the exhibit of this press release that the defense attorneys, released to the public, which we've gone over before as well. We've literally read all of this before. I remember doing that. And as I say, if you look at the dates in the timeline, the gag order was not even in place officially yet. There was just a request for it. So I don't know what McCleland is going to do about that, because his own timeline here, his own bullet points are proving that. Well, let me know what you think about this. After everything, especially if you watched yesterday's episode, the live stream, go and check it out. It's timestamped for you. And if you see this, What do you make of this? Do you think that, I don't know, let me know what you think. There's so many ways we can look at this. In my opinion, as I said in the beginning, I think this is a desperate attempt to come to Judge Gull's rescue, because I think the defense raised some really good, valid points about Judge Gull's conduct. So to now put the defense attorney's conduct in question when they've just been reinstated by the Supreme Court of Indiana, I think this is a winning battle for Nicholas McCleland, and I think he should focus on getting the case back on track. And if he is so concerned about the victims and their families, then do that, okay? Then focus on that. Be concerned about that. Let Richard Allen be in a freaking jail where he can be kept safe, because yesterday we read a document where McCleland said he doesn't care where he is. He doesn't care where he's housed. Okay, then let him be in a jail, closer to his attorneys. Let them be able to see him face to face, which is not allowed currently where he's at. They have to be like 6 feet apart and talk through some little slot in a metal door and all sorts of things. That's just not the way it should be done. He's innocent or proven guilty. He's not yet convicted. Even if people like to have that argument of, oh man, look at the allegations. He's a child killer and he should be in prison. He shouldn't be in prison yet, and he shouldn't be treated like that yet. And if he's in jail and he's treated like a alleged child killer would be treated, that is normal. We see that in so many cases. That could happen. But to escalate it, to put him in a prison, and then for two sets of defense attorneys to raise the same concerns should be a concern for the state prosecutor and the judge if they really want to see justice for Abby and Libby. If they really want this to be a fair trial, let it be fair. Why are you kicking against all this stuff? It's weird. It raises a red flag. Okay, so I'm going to leave it at that for now. Thank you so much for watching this. I know this case is very document heavy at the moment. Documents, I know, are not for everyone, but if you want to follow, presentations, maps, and videos, and police interrogations, and things like that, there's many cases that I cover that you could tune into if this is not your thing. But I know many of us here, we love documents and all the things, map time, timelines, documents, all this that's happening. And of course, we, as we say, represent kind of like an international mock jury, because we have an international audience here, and I myself am South African and I'm living in Europe, and when I look at this, I just smell corruption. That's it. There's no other way for me to say it. It's shady, it's weird, it shouldn't be happening like this. We don't see this happening in any other case, and definitely not every other case. Like, what is going on here? There must be a standard, things must be done right. And I really hope that things will get back on track soon. Can they play nice? McCleland, can you it seems like it's like a battle of egos in the small town. That's what it feels like, right? And it's horrifying. It's horrifying to watch and extremely sad. Okay, so I will keep you posted on what happens next, because there's for sure going to be something else next. Either a hearing, maybe we'll hear the judge recused herself, maybe we're going to see her kicked back, maybe we're going to see the Supreme Court of Indiana get involved again. Who knows? We'll see what happens next. Thank you so much, and I'll see you in the next one. Stay safe.